Item 1.
Made, please, yours. The previous day, my lord, I argued point number 1 that the aggrieved party is not before your lordship.
Yes.
And aggrieved party is not before your lordship, and the law is well settled, my lord, that the party aggrieved should have approached this honorable court against the decision, even in case of claim or due which is time barred, my lord, and the aggrieved party is not challenging, my lord, that then the writ is not maintainable. That point I have already concluded, my lord. The second point which I am arguing, my lord, today,
Yes.
second point which I am arguing, my lord, resolution plan does not meet the requirement of section 30 subsection 2 and therefore it is not binding. Section 30 subsection 2 of Insolvency and Bankruptcy Code, IBC Code 2016, my lord, and therefore it is not binding, my lord. And in support of my plea, my lord, I rely on two judgments of the Honorable Supreme Court, my lord. 2022 SCC Online SC 1162 and second judgment is 2023 SCC Online SC 1406. Kindly see section 30, my lord, section 30 of IBC Code. Section 30. Submission of resolution plan, my lord. A resolution applicant may submit a resolution plan along with affidavit stating that he is eligible under section 29 capital A to the resolution professional prepared on the basis of information memorandum. My lord, kindly see 32. The resolution professional shall examine each resolution plan received by him to confirm that each resolution plan provides for payment of insolvency resolution process cost in a manner specified by board of other debts or corporate of the corporate debtor, my lord. B. Provides for the payment of debt of operational creditors in such manner as may be specified by the board, which shall not be less than the amount to be paid to the operational creditor in the event of liquidation of a corporate debtor under section 53, my lord. So resolution plan under section 30 subsection 2B, my lord, requires to give the details of debt of operational creditor, my lord. That is the requirement of resolution plan. Section 32B, my lord.
Yes.
And my submission is that the resolution plan has not taken into account the dues of operational creditor before your lordship. And therefore this resolution plan is not binding, my lord.
That is the power supply dues.
Yes,
consumption charges.
in resolution plan, my lord, under section 32, the resolution professional has to take into account, provide for debt of operational creditors.
No, this is the submission of the resolution plan.
Yes, my lord. So
There is the approval process.
31, my lord, 31. If the adjudicating authority is satisfied that the resolution plan as approved by committee of creditors under subsection 4 of section 30 meets the requirement as referred to in subsection 2 of section 30, it shall by order approve the resolution plan, which shall be binding on the corporate debtor and its implies members, creditors, guarantors and other stakeholders involved in the resolution plan, my lord. So meets the requirement as referred in subsection 2 of section 30, my lord. So meeting of the requirement of section 30, subsection 2 is sine qua non approval of the resolution plan. If the requirement is not met, that resolution plan is not binding.
No, but suppose the resolution plan does not take into account the dues of a
Corporate debtor,
corporate debtor,
operational creditor, my lord.
and it is approved by the adjudicating authority.
Yes, my lord.
What is the remedy in this code against such an approval?
So, my lord, the remedy, my lord, is that it is what the Supreme Court has declared, that it is not binding on the operational creditor.
No, there is no appeal mechanism.
There is an appeal mechanism under section 62, my lord, but the court says, my lord, there is an appeal mechanism, but the Supreme Court says that it is not binding. So if I am, in case, my lord, I am operational creditor and my debt has not been taken into account by the resolution plan under 30 subsection 2, my lord, then the law says that it will not be binding on me. This resolution plan will not be binding on me. That is how this section 30 subsection 2 has been interpreted in Sales Tax Officer versus Rainbow Papers, my lord.
No, that is all right, but then suppose an order or decree is passed by a court.
Yes, my lord.
Nobody appeals from that decree.
Yes, my lord.
Now, suppose the
Whether it is in rem or in person, my lord.
suppose the case is that there was non-joinder of a necessary party, and a decree has been passed against that party without impleading him or hearing him or etc. etc.
Yes, my lord.
And for some reason that party has not preferred an appeal or made an application to set aside an ex parte order.
Yes, my lord.
Now that order or decree becomes final.
Yes, my lord. That order and decree becomes final, my lord. But
so unless it is a nullity, how can a court say that it is not binding?
yes, my lord. So the so far as decree and judgment, I bow down
to the Supreme Court.
Yes, my lord.
So unless the Supreme Court holds
Yes, my
that for not taking into account corporate debtors' dues,
Yes, my lord.
a resolution plan is approved, etc., by the adjudicating authority.
Yes, my lord.
If it is held that it is a nullity,
Yes.
then end of the matter. But if it is not, how
Yes, my lord.
how
Kindly
is it not
see.
binding?
Yes, my lord. Kindly see the what is falling from your lordship. That aspect has been considered in Sales Tax Officer versus Rainbow Papers. In page 1, my lord. Page 1, paragraph 1, my lord. These appeals under section 62 of Insolvency and Bankruptcy Code 2016, hereafter referred as IBC, is against the judgment and order dated 19th December 2019, passed by Company Law Appellate Tribunal, dismissing the company appeal, insolvency number so and so, filed by the applicants against the order of 27 February 2019 of adjudicating authority, rejecting the application being number so and so, filed by the appellant, and holding that government cannot claim first charge over the property of the corporate debtor as section 48 of Gujarat Value Added Tax 2003, hereinafter referred as GV Act, which provides for first charge on the property of a dealer in respect of any amount payable by the dealer on account of tax, interest, penalty under the said GV Act cannot prevail over Section 53 of the IBC. After noting this factual background, my lord, kindly come to paragraph 19. Sorry. At page paragraph 35, my lord, or before that, my lord, kindly see paragraph 25. Sorry, page 11. In this case, at the cost of repetition, it may be noted that there was no obligation on the part of state to lodge a claim in respect of dues which are statutory dues for which recovery proceedings have also been initiated. The appellant were never called upon to produce the material in connection with the claim raised by the appellant towards the statutory dues. Adjudicating authority as well as the appellate authority and NCLT misconstrued the regulation. On behalf of the appellant, it has been argued that there were proceedings initiated by against the corporate debtor to realize its statutory dues. Books of account of corporate debtor would have reflected the liability of the corporate debtor to the state in respect of statutory dues. In abdication of the mandatory duty, RP failed to examine the books of account of the corporate debtor, verify and include the same in the information memorandum, and make the provision for same in the resolution plan. The resolution plan does not conform to the statutory requirement of IBC and therefore not binding on the state. And then, my lord, after recording the submissions, my lord, kindly see paragraph 35 at page 12. The learned ASG emphatically argued that RP was obliged to receive, verify and collate claims and forward the same to the adjudicating authority for approval. Learned ASG cited Swiss Ribbons versus Union of India, where the court held that resolution professional does not have the adjudicatory power to accept or reject the claim. His duty is only to receive, verify and collate the claims. Referring to section 30 subsection 2 of IBC, learned ASG argued that aforementioned provisions mandate the RP to ensure that resolution plan conforms to the parameters and requirements laid down in the said provision. It was the duty of the resolution professional to examine, ensure and verify the resolution plan conform to the parameters and requirements laid down in subsection 32 of IBC. Further, section 29 of IBC cast a statutory duty and an obligation on the resolution professional to prepare the information memo after following the procedure laid down in the code. And then learned ASG pointed out that section 29 of IBC, resolution professional is required to prepare the information memorandum. Information memorandum is mandatorily required to contain details as mentioned in regulation 36(2) of regulation. And then, my lord, all these details are required. Then kindly see paragraph 41 at page 13. Section 31 of the IBC provides for approval of resolution plan by the adjudicating authority, makes it clear that adjudicating authority can approve the resolution plan only upon satisfaction that resolution plan as approved by the committee of creditors meet the requirement of section 30 subsection 2 of IBC. When the resolution plan does not meet the requirement of section 30 subsection 2, the same cannot be approved. In Ghanshyam 42, in Ghanshyam Misra versus Edelweiss Asset Reconstruction, cited by learned Solicitor General of this court observed, it could thus be seen that legislature has given paramount importance to the commercial wisdom of COC, and the scope of judicial review by the adjudicating authority is limited to the extent provided under section 31 of IB code, and the appellate authority is limited to the extent provided under subsection 3 of section 61 of IB code and is no more res integra. Bare reading of section 31 of IB code would also make it abundantly clear that once resolution plan is approved by adjudicating authority, after it is satisfied that the resolution plan as approved by COC meets the requirement as referred to in subsection 2 of 30, it shall be binding on the corporate debtors. Corporate debtors and its implies members, etc. My lord. After quoting the Edelweiss, my lord, in paragraph 43 at page 14. The learned Solicitor General rightly argued when a grievance was made before the adjudicating authority with regard to a resolution plan, the adjudicating authority was required to examine if the resolution plan met the requirement of section 30, subsection 2 of IBC. The word satisfied used in section 31 contemplates a duty on the adjudicating authority to examine the resolution plan. The resolution plan cannot be approved by way of empty formality. And then, my lord, 45. As rightly argued by learned Solicitor General, there can be no question of acceptance of resolution plan that is not in conformity with the statutory provisions in section 31(2) of IBC. Section 32(b) of IBC casts an obligation on the resolution professional to examine each resolution plan received by him and to confirm that such resolution plan provides for payment of dues of operational creditors as specified by board, which shall not be less than amount paid to such creditors in the event of liquidation of corporate debtor under section 53, or the amount that would have been paid to such operational creditor if in accordance with the order and priority, etc. 46. Under section 31 of IBC, a resolution plan as approved by committee of creditors under subsection 4 of 30 might be approved by adjudicating authority only if adjudicating authority is satisfied that resolution plan as approved by committee of creditors meet the requirement to as referred in subsection 2 of section 30 of IBC. Condition precedent for approval of resolution plan is that resolution plan should meet the requirement of subsection 2 of section 30, my lord. And then the judgment is quoted, my lord, and 48, which I am paragraph 15. A resolution plan which does not meet the requirement of subsection 2 of section 30 of IBC would be invalid and not binding on the central government, any state government, any statutory or other authority, any financial creditor or any creditor to whom debt in respect of dues arising under law for time being enforced is owed. Such a resolution plan would not bind the state when there are outstanding dues of a corporate debtor. So I rely on paragraph 48 and then, my lord, 52. If the resolution plan ignores the statutory demands payable to any state government or a legal authority, altogether the adjudicating authority is bound to reject the resolution plan, my lord. So this judgment was, my lord, challenge, review was sought of this judgment, my lord, before the Honorable Supreme Court at page 17, my lord, that is Sanjay Kumar Agrawal. And the review petition was also dismissed, my lord. Kindly see paragraph 19 at page 24. Page 24, paragraph 19. Learned senior counsels and learned counsel for the review petitioners intervener placing heavy reliance on the observation made by two-judge bench of this court in Paschim Anchal Vidyut Vitran Nigam versus Raman Ispat Limited, delivered on 17 July 2023, submitted court in the impugned judgment had failed to consider the waterfall mechanism contained in section 53, as also failed to consider other provisions of
IBC. You go to this, Mr. Advocate General.
Yes, Lord.
You come to paragraph 58
of the first judgment.
Yes. It has gone to Supreme Court via NCLT.
Via NCLT. Yes, my lord.
So, appeal to the appeal to whom? From the resolution plan?
The adjudicating authority is NCLT, my lord. NCLT is appellate authority, and from NCLT it has gone to the Supreme Court in this case, my lord, Rainbow Papers.
So, here there is...
here I have
not taken any...
Yes, my lord. Here in this case,
here the Supreme Court, I made a mistake in appreciating the ratio of this judgment. Not that a resolution plan approved which is contrary to the stipulation is not binding.
Yes, my lord.
But here in its appellate capacity, the Supreme Court has held over,
Yes, my lord.
over the order of the NCLT.
Yes, my lord. Your lordship is right.
That the NCLT ought to have held it is not binding,
Yes, my
but
lord.
it has not.
Yes, my lord. Your lordship is right. So the
But
principle,
here, not having taken any proceedings,
whether the ratio, yes, my lord, the question which falls from your lordship's is that whether if I have not resorted to the proceedings under the IBC, whether it is open for me to canvass the argument that this resolution plan is not binding under section 330 subsection 2 of the IBC code, my lord. My submission is, my lord, that the law declared in this case is that any plan which does not take into account the operational creditor, it is not binding, my lord. That is paragraph 48 of the Honorable Supreme Court. That is a declaration of law. And I need not resort to the IBC mechanism to because if the Honorable Supreme Court has declared the law, my lord, that if the in paragraph 48 in clear terms, my lord, then I need not, because it clearly says in paragraph 15, so it is not binding on me. This resolution plan is not binding on me, my lord. And if it is not binding, I need not challenge because it has not taken into account the dues of operational creditor. My dues have not been taken into account. That is the crux of and sum and substance of my submission, my lord, yes, on this point. The another point is, my lord, because this judgment records one aspect of the matter is that there was no obligation on the part of the operational creditor to lodge the claim also, my lord. There is no obligation on the part of the what has been, if your lordship will see the finding of learned single judge on this aspect of the matter, the point which I have argued, at page 57 of at paragraph 18, one paragraph where the learned single judge deal with the Ghanshyam Mishra and Edelweiss, which has been taken into consideration in Rainbow Papers, my lord. And Rainbow paper was questioned also, my lord, in review in Sanjay Kumar Agarwal. And there also the Honorable Supreme Court affirmed the view taken by the division bench in cell tax paper versus Rainbow papers, my lord. Kindly see the impugned judgment at page 56 and 57.
of this compilation.
Of the writ appeal, my lord. No appeal. Impugned. Because I have shown the case law and the learned single judge has dealt with that aspect, my lord, in paragraph 18 at page 57.
Page
57 at paragraph 18. Page 57, my lord, paragraph 18. Further, in the above proposition that is applicable to the instant case has also been dealt in Southern Power so and so, my lord, wherein Supreme Court has held that clean slate principle will stand negated if the successful resolution applicant is asked to pay the arrears payable by corporate debtor for grant of an electricity connection in his or her name. Argument put by respondent number 1 by placing reliance in the case of a state tax officer versus Rainbow papers that any resolution plan which overrides a statutory duty is invalid and not binding to the mind of the court will have no application in the instant case as the respondent number 2 never filed any claim in accordance with law, and further this said decision was rendered in regular appeal which was preferred under section 2 of IB code. So two reasons have been weighed. Two reasons have weighed with the learned single judge. One, that I did not lodge any claim, my lord. And second is that decision was rendered by the Honorable Supreme Court under Section 62 of INB Code. My Lord, so far as the first reason is concerned, kindly the notices for the claim, my Lord, was not sent to me. It was sent to the Meghalaya State Electricity Board, which became defunct in 2000, which was dismantled, and distribution companies came into existence in 2010. So at page 64, my Lord, the notices have been sent to Meghalaya State Electricity Board, and it was never sent to the distribution company, my Lord. So therefore, there was no occasion for me to lodge the claim. Page 64. Second submission is, my Lord, if a law has been laid down by the Honorable Supreme Court, either under the IBC Code or under any other law, that law is binding, my Lord. That law could not have been ignored on the ground that decision has been rendered under Section 62 of INB Code. Law declared by Supreme Court, my Lord, either under INB Code or any other provision, my Lord, is binding. So the judgment of Honorable Supreme Court in State Tax Officers versus Rainbow Papers Limited could not have been ignored on the ground that the law has been rendered under Section 62 of INB Code, my Lord. So therefore, my humble submission, the learned single judge has gone wrong in discarding the law laid down by, or not applying the law laid down by the Honorable Supreme Court on the ground that law has been declared under Section 62 of the INB Code. And there was no occasion for me to lodge the claim also, because notice has never been served. And that is the aspect which the Honorable Supreme Court in Rainbow Papers clearly says, and it says that there was no obligation on the part of the authority to lodge claim, because all details are with the resolution professional, my Lord. So this is my second point, my Lord. Third point, my Lord, is with regard to my submission is that even resolution plan also protects my right, my Lord. Under the resolution plan, all statutory obligations have been protected, my Lord. Kindly see one page of the resolution plan, page third submission. 293 is the resolution plan.
What was the second?
Second submission is, my Lord, that the resolution plan which do not conform to requirement of Section 30, subsection 2 is not binding.
Is that you already said?
Yes, my Lord. Third is that factual detail, even resolution
Your
plan.
first is aggrieved party not before the court.
Yes, my Lord.
Second is this.
Yes. Third point is, my Lord, that even under the present resolution plan, my rights have been protected. Right to claim statutory dues have been protected, my Lord.
Yes.
And for that, your Lordship, kindly turn over to page 293 of appeal book, my Lord, the resolution plan. Annexure 9, my Lord, is the resolution plan. And the relevant page of the resolution plan on which I am placing reliance is at, Lordship will find at 310. 310, small Roman 3, my Lord. Small Roman 3 at 310, my Lord. The 310 at small Roman 3, my Lord. The approval of resolution plan shall not be construed as a waiver of any statutory obligation of the corporate debtor and shall be dealt by the appropriate authority in accordance with law. Any waiver sought in the resolution plan shall be subject to approval by the authorities concerned. So, in my humble submission, my Lord, the resolution plan protects the liabilities of statutory obligations of the corporate debtor, my Lord, and therefore there is no waiver of statutory dues, my lord. What has been argued in the written submission, my lord, that statutory obligations are different from statutory dues. My dues of the power distribution companies are in the nature of statutory dues, and it will not come under the ambit of statutory obligation. And therefore, this small Roman 3 at 310 will have no applicability. That is what has been argued, saying that waiver shall not be construed as a waiver of statutory obligation, will not include my statutory dues, my lord. I have placed three authorities, my lord. I have placed two authorities on that point at serial number 3 and 4, my lord, of the case law, of the compilation, my lord. In the compilation, my lord, at page 34 of the judgment compilation, my lord, of Telangana State Southern Power Distribution Company versus Sriganda, my lord, the Honorable Supreme Court has held that dues of electricity companies are statutory dues, my lord. At serial number 34, my lord. At page number 34, serial paragraph 10, my lord. We may also note that there have been subsequent judicial pronouncements dealing with the aspect of electricity dues. A three-judge bench of this court has held that dues under the terms and conditions of supply partake the character of statutory dues.
Page 34.
Page 34, paragraph 10, my lord.
Okay.
The dues of a three-judge bench of this court has held that dues under the terms and conditions of supply partake the character of statutory dues. That mere fact that agreement were entered, and then, my lord, it takes, and then paragraph 16.1. The electricity dues which are statutory in character under the Electricity Act and as per terms and conditions of supply cannot be waived in view of the provisions of the Act itself. More specifically, Section 56 of Electricity Act 2003, pari materia to 24 of 1910, and cannot partake the character of dues of purely contractual nature. So these two paragraphs leave no scope of doubt that the dues of electricity companies are in the nature of statutory dues under the Electricity Act, my lord. And to the same effect, the judgment of the Honorable Supreme Court at serial number 4 is KC 9 versus Kerala SEB, my lord. I have already paragraph 79, 83, 83 on the same proposition that dues of electricity companies are statutory dues, my lord. And read with page 310, small Roman 3, my lord. The resolution plan itself provides that there shall be no waiver of statutory obligations. Now, the learned senior counsel in the written note has said that statutory obligations are different from statutory dues, my lord. In my humble submission, the statutory obligation will be in the nature of larger concentric circle, and within that larger concentric circle, a smaller concentric circle of dues will come, my lord. That is my third point, my lord.
No, which is the other case?
The other case is, my lord, KC 9 versus Kerala at serial number 4 of my judgment compilation, my lord. 2023 SCC online, SC 663, paragraph 79, 83, 89, my lord. So my submission is, my lord, that resolution plan protects my claim. There is no waiver of my dues under the resolution plan, my lord. And the last but not the least, my lord, is that the petitioner has the alternative efficacious remedy under section 60, subsection 5 and C of IBC code, my lord. Kindly see section 60. of the IBC code, my lord. Alternative efficacious remedy. My first was that aggrieved person is not before your lordship. My second point was that section 30 subsection 2, and third point was, my lord, that the resolution plan protects my rights to recover the amount. And fourth is, my lord, alternative efficacious remedy, my lord. Kindly see section 60 of INB code, my lord. And section 60 subsection 5, my lord. Notwithstanding anything to the contrary, section 60 subsection 5, my lord. Notwithstanding anything to the contrary contained in any other law or time being enforced, the National Company Law Tribunal shall have jurisdiction to entertain or dispose of. Now see, my lord, any question of priorities or any question of law or fact arising out of or in relation to insolvency resolution or liquidation proceedings of the corporate debtor or corporate person under this code. So the NCLT, my lord, under section 60 subsection 5C has the jurisdiction to entertain question of priorities or question of law or fact. Now the question of law and fact which may arise in this case, my lord, is that whether as per the respondent, my lord, whether the statutory obligations will contain the statutory dues or it will not be included within the ambit of statutory obligation, and that issue could have been adjudicated by adjudicating authority, that is National Company Law Tribunal, under section 65 and C, my lord. This argument, my lord, I have taken before the learned single judge, and that has been dealt, if your lordship will kindly see last page of the impugned judgment, that is at page 58, paragraph 19.
What has his lordship held?
Lordship held that there is a waterfall mechanism, and therefore, since I am hit by waterfall mechanism, that is precisely under section 31, this remedy is not available to me. Paragraph 19, 4 lines, my lord, page 58. On the other challenge that writ petition is not maintainable due to the availability of alternative efficacious remedy by virtue of section 65C of INB code, this argument is not accepted as writ petition is clearly seeking a mandamus in view of the action of the respondent number 1 and 2, where in spite of binding nature of section 31 of INB code are denying the writ petitioner electricity connection by making the same contingent upon recovery of pending dues not attributable to it. Judgment referred by learned Advocate General on different footing are of no assistance and discussed here. 3 judgments I have cited, my lord, before the learned single judge, and they are part of my compilation, my lord. If your lordship will see the first judgment, my lord, at serial number 5 of my compilation.
Five, six, seven.
5, 6, 7, my lord.
What is waterfall principle?
Waterfall is that once the resolution plan is approved by the adjudicating authority, all claims of corporate debtor, operational debtor will get extinguished. And no claims will survive after the acceptance of resolution plan, my lord.
Subject to further addition, your lordship, waterfall mechanism contemplates a
No,
hierarchy of payments on the
do you have a senior? Do you have a senior in the matter?
Yes, I have a senior, I think.
Who has authorized you to overreach him and make submissions? Don't do this in this court.
So 3 judgments, my lord, I rely on this paragraph 7 at page 158 of this judgment, my lord. At 1964 SC 1419. Against the order of the commissioner, an order for reference could have been claimed if the appellant satisfied that commissioner or the High Court that a question of law arose out of the order, but the procedure provided by the Act to invoke the jurisdiction of the High Court was bypassed. Appellant moved the High Court challenging the competence of the provincial legislature to extend the concept of sale and invoke extraordinary jurisdiction of the High Court under 226 and sought to reopen the decision of taxing authorities on question of fact. The jurisdiction of the High Court under 226 of the Constitution is couched in wide terms and exercise thereof is not subject to any restriction except that territorial jurisdiction are expressly provided in the article. But the exercise of the jurisdiction is discretionary. It is not exercised merely because it is lawful to do so. The very amplitude of jurisdiction demands that it will ordinarily be exercised subject to certain self-imposed limitations. Resort that jurisdiction is not intended as alternative remedy for its relief, which may be obtained in a suit or other mode prescribed under the statute. Ordinarily, the court will not entertain a petition for a writ under 226 where the petitioner has an alternative remedy, which without being unduly onerous provides an equally efficacious remedy. Again, the High Court does not generally enter upon determination of question which demand an elaborate examination of evidence to establish the right to enforce which writ is claimed. The High Court does not. So this is the law, my lord, and this is similar judgment in paragraph 30, Sidco, my lord. Para 30 of the next judgment at page Lordship 170. Same principles reiterated, my lord. And Sanjay Kumar Jha, my lord, I have already referred those paragraphs in my index, my lord. I need not trouble your lordship with repeating. So my point, my lord, is that under section 60, subsection 5C, they are not denying that there is no alternative efficacious remedy. It's not in their written submission, my lord. I have gone, and in written submission also, they have not said that it is not alternative remedy. It is an alternative remedy. And if it is an alternative remedy, my humble submission is, my lord, that this would have been left to the adjudicating authority. They could have gone before the adjudicating authority and they could have raised that within the ambit of statutory obligation, statutory dues are also covered, my lord. So these are all 4 submissions I have to make, my lord.
You wish to file notes?
Yeah, I will file note, my lord.
Yes. Now, yes, Mr. Shastri. Is he a senior online or offline? It's not audible.
You are not audible.
Unmute yourself.
Yes, I'll just check, Your Lordship. I think he's on legs in a court. And
no, then it's all right. Then you have full liberty to submit. I thought he was online.
He was
online.
No, if he is not there, you hold the fort. No problem.
Mr.
No, I'm here. See, my lord, I'm here. My lord, I'm here. Am I audible?
Yes. Mr. Advocate General has completed his submissions.
Will your lordships, my lord, consider having it on Thursday, my lord? I'll complete it.
This Thursday?
This Thursday I'll complete it. My friend has completed, I understand.
That is 20th.
20th, my lord. Will your lordship, my lord, some fixed time slot may be given, my lord. I'll complete. I'll take only half an hour. Please, half an hour. If it pleases your lordships.
Is there any other bench?
Only one at Thursday. Only
No.
this bench.
Is there any bench with Justice Bhattacharya? Or... No? I'll fix it at 12:30. 12:30?
10:30.
12:30.
Extremely obliged.
12:30.
12:30.
12:30.
12:30. We'll complete.
Yes. Learned Advocate General concludes his argument. List this appeal to hear Mr. Venkataraman, learned senior advocate, appearing for the respondents, on 20 March, marked at 12:30 p.m. or after exhaustion of matters in the regular bench, whichever is earlier. Mr. Additional Solicitor General, you don't worry. If the list is exhausted before, Mr. Sastry will start and you come and join him at 12:30.
I'll try to be even before. I'll take only 25 to 30 minutes on time because this court will take only that much time for this matter.
No, yes.
Extremely obliged.
Thank you.